Uh, Thank you, Ann. I'm really happy to have this next presentation about some pending legislation that's called the Judicial Discretion Act. One of the things that I really like about this legislation is that it wasn't born out of the Office of Public Defense, and that this legislation was first contemplated and thought about within the confines of different Department of Correction facilities. And so folks who had been sentenced got together and talked about what would be fair moving forward. One of the things that I really appreciated that they talked about is folks that had been harmed and victims. And so, I see this pending legislation as a something that's very important, that this would be second chance legislation for folks who are currently in prison, who would be able to show the work that they've done, and that it would be safe in regards to public safety, that they would be released. And furthermore, that they would go to court and do this in front of a judicial officer. Right now, there isn't a pathway for this to happen. Only prosecutors can do it. And right now, under what's called 6164, a Senate bill from many years ago, it just hasn't been very effective pathway. And primarily because it doesn't come with counsel and a team that can assist an individual. And so this legislation would do that. And so I'm really proud to have worked with Charles Longshore now for about 2 years and 5 months. We've never met in person, but we have talked on the phone many, many times. And so I'm really proud of his leadership and the leadership that not only he carries, but the leadership of the Judicial Discretion Act team, because Charles isn't doing this alone. He's doing this with others as well. And so with that, I want to give this over to Mr. Charles Longshore.
Hi, Molly. Thank you, Larry, and thank you, everyone, for allowing me and our team to have an opportunity to present today about the bill. The Judicial Discretion Act is our state's second look legislation. Under this bill, incarcerated persons who have served 10 years or more, if an adult, or 7 years or more, if a juvenile, would be entitled to have a second look of their sentence after meeting specific criteria. A significant record of rehabilitation while incarcerated where a person presents a low risk of reoffense, or 2, suffers from a terminal or other serious medical condition that is permanent, degenerative in nature, resulting in a person to no longer be a threat to public safety. In understanding the impact this has on crime survivors for resentencing hearing, the JDA also includes a robust package to ensure their needs are met as we go back and have a second look. In fact, there's a portion of the bill that says if there's an adverse impact on a crime survivor, the judge can deny the petition. History of bill. The JDA was drafted by myself and other directly impacted people following the American Bar Association Resolution 502 and NACDL, National Association of Criminal Defense Lawyers Model Penal Code. In Washington State, nearly half our prison system are persons serving lifelong sentences. In response to this silent and growing crisis, the JDA was formed, and the JDA Coalition, now known as the Judicial Second Look Coalition, was founded. Under Resolution 502, the American Bar Association called for federal, state, local, and tribal governments to authorize judicial decision makers to hear petitions for de novo second look resentencings by incarcerated persons who have served 10 years or more of incarceration. Further, the American Bar Association and American Law Institute listed parole as a failed institution. According to a recent sentencing project report, legislators in 12 states, the District of Columbia, and the federal government, through bipartisan efforts, enacted second look mechanisms authorizing judges to review sentences imposed. Last session, the JDA passed the House and died in the Senate Law and Justice Committee. This year, we have done significant stakeholder and legislator meetings in both the House and Senate. House Community Safety Committee, Roger Goodman, Chair, has listed JDA as a priority for the 2025 session for his committee. DINGRA has also agreed to hear the bill. We have met with Senate leadership, Ways and Means members, and members of Law and Justice. For all purposes and intent, the JDA is well positioned for the 2025 session, and I now turn it over to my colleagues. Judge McKee, Kim Gordon, and then Izzy Eads.
The Judicial Discretion Act, the JDA, is a necessary piece of legislation which will redress the harms of the past and promote a safer society moving forward. Throughout the history, the justice system has in many ways helped maintain or even exacerbate racial, ethnic, and economic inequities. We know this. As a judge, I am asking for a tool to help me avoid maintaining or exacerbating these historical and current harms. As one of my colleagues has succinctly explained, while we truly do our best when sentencing individuals with the information we have, judges don't have crystal balls providing us with information about how people, after their original sentencing, will heal from past trauma, gain insight into the harm they have caused, and develop the ability and desire to help others heal. The Judicial Discretion Act is this tool. As I have conducted an increasing number of resentencings and talked to colleagues who have done the same, it is clear to me there are incarcerated individuals who are not only safe to join us back into the community, but will actually help make our society a safer one due to their own healing and growth. In addition, a growing body of data shows that many individuals serving lengthy sentences are low to even no risk of recidivism. The JDA acknowledges the way in which people heal and rehabilitate and provides judges with an opportunity to respond accordingly. The stated purposes of the Sentencing Reform Act include promoting respect for the law by providing punishment, which is just, protecting the public, offering the offender an opportunity to improve himself or herself, making frugal use of the state's and local government's resources, and reducing the risk of reoffending by offenders in the community. The Judicial Discretion Act furthers all of these stated purposes of our sentencing code. I ask that OPD give full support to the Judicial Discretion Act. Thank you so much for your time.
Good morning. I'm Kim Gordon. I'm a defense attorney in Washington State, where I have practiced for almost 3 decades now. I am volunteering my time to help move the JDA forward because it is unique in what it offers to the people of Washington State. We do not have a meaningful mechanism for review of or taking a second look at cases for those people who have demonstrated that they have merit. And you are hearing today from some of the people who have merit and who have something very real to offer our communities if they are out of custody. But in order for the second look process to be meaningful, in order for the JDA to work, we must also have the right to ensure fundamental fairness in the proceedings, and that comes through the provision of counsel. I am pleased to say that even though the provision of counsel is of utmost importance, this bill will not have an impact on local public defense workloads. I am from one of what I understand are dozens of attorneys who have so far responded that they want to be a part of judicial resentencings and are excited to contract with the Office of Public Defense to take JDA cases. I spent the first part of my career, a huge part of it, as a public defender. And when I went into my practice, I assumed that I would do that for the entirety of my career. But my personal obligations and frankly, my health made it not tenable for me to do that for my entire life. And so at a certain point, I started my own private practice, What I found is that I could do things in that private practice that I didn't have the time or necessarily the expertise when I was a public defender. Now, for around 6 years, I've been handling resentencings and other second look cases. I know I can bring the expertise that I have developed to these cases to ensure fundamental fairness. And I've got to tell you, I already do this when I can find a way into court for clients that can afford to pay. And many people on this call will know that I try to have a generous pro bono representation practice in my office, but I cannot sustain our state's obligation to ensure access to the courts through my pro bono representation. So there are many worthy individuals who are left without assistance. And without that, things go poorly. It takes more court time, and it puts a greater burden on the prosecution. Ultimately, fairness is not achieved. Doing these cases won't make me rich. I could do more handling private cases, but like many of my colleagues, I want to do what I can to make the system fairer and to undo the wrongs that have been perpetuated, perhaps unintentionally, by the system as it existed before today. I ask you all to join me in doing that as well. Thank you.
I'm going to use my time to share some words from folks who are directly impacted by this piece of legislation.
Hello, everyone, and thank you for your time. My name is Carlos Bernardes Jr. I'm currently incarcerated in Washington Correction Center at Shelton, Washington. My incarceration began in January of 2009 when I was charged with first-degree murder and took down some second-degree assault. At the time of my incarceration, I was 18 years of age, and after fighting my case for a year and a half in the King County courts, I pled guilty and took an Alpha plea for 360 months. As I've had the time to reflect and think of how the Judicial Discretion Act would be of service, I'm reminded at the fact that without this bill, changes like youthful offender laws cannot apply to me because those significant changes did not exist at the time of my sentencing. 16 years into a 30-year sentence leaves me roughly 13 years left to do. However, with the second look, with my age being taken into consideration, as well as my programming history, family, community support, and just the man who I am today, I believe wholeheartedly my outcome would look a whole lot different. I pray for an opportunity at a second look. Thank you.
Once the court has made a judicial determination that a sentence is grossly disproportionate and does not fit, wouldn't that classify as an injustice or an inadequacy in substantive or procedural law? What happens after a court has made such a determination? What mechanism currently exists to enforce RCW 36-27020? There is not one. That is why we need the Judicial Discretion Act. I'm currently on appeal for no other reason than my court lacking any mechanism he believed to fix an appropriate sentence. He said in his ruling and on the record, after finding mitigated factors of youth and prodigious rehabilitation, that my sentence doesn't fit the crime when evaluating me as I am today and is grossly disproportionate. My current sentence consists of 378 months flat of firearm sentencing enhancements. My court did all he felt he could, and that was give me 0 months on the underlying count. The prosecuting attorney, who is now retired, stated on the record the only way my judge could remove the enhancement portion of my sentence was if he, the state, moved to vacate him, which he said we are not going to do. However, this is exactly what he did just a few months prior for my co-defendant, vacating 6 of her 7 firearm sentencing enhancements. My case is a primary example, not the example I might add, of exactly why sentencing courts must have the discretion, after weighing all of the facts of a given case, to impose an appropriate sentence. Without sentencing courts having this discretion, money is spent on needless appeals. Lives are spent in a carceral setting as opposed to in the community and with family, as well as state resources being spent to incarcerate someone who no longer needs incarceration. Without a mechanism in place to balance the charging discretion that prosecuting attorneys have with the judicial discretion our sentencing courts so rightfully deserve, The system as it exists in Washington State is a lose-lose. It serves not the improvement of lives and community safety, but rather mass incarceration driven by personal animus and bias. This will not do, cannot be sustained, and must give way to a better, more humane approach. Thank you.
My name is Amanda. I was sent to prison with charges based on accomplice liability, and it took several years for me to take accountability for my actions, which I achieved through healing and a desire for growth. I have spent the last 15 years in prison and have completed every class available to me. I facilitated several of them. There's a misconception that when society sentences someone for their crimes, that person is held accountable. Most people don't honestly know what that even means. Prison doesn't heal, whether victim or perpetrator. Sentencing guidelines do not account for the fact that incarcerated women are more likely to have suffered physical or sexual harm. Prison doesn't make someone accountable or make them grow. People do that. Accountability, growth, and healing are learned behaviors, not manufactured outcomes. With no opportunities left for growth, I am really being warehoused. The Judicial Discretion Act would allow a judge to recognize the effort I have put forth to be the community member my society needs me to be, and give me an opportunity to be accountable to my family and community back home.
And then I just want to add on to this discussion. My colleagues have made all of the amazing points that we talk about all the time with this bill. But I think the other thing that we need to look at is from the human perspective. We all know the disproportionality, how it's impacted entire communities and our society as a whole. And we know that the issue of mass incarceration is huge. It wasn't one misstep that got us here. It was multiple issues throughout a very long period of time that sort of led to this gargantuan problem. But we need to start moving the needle back, especially in light of like the current budget issues. I know we talked about that a little bit earlier in this meeting, but it is incredibly expensive to be incarcerating people who could otherwise be out in our communities contributing in positive ways. So there's a real like opportunity cost there that we are paying that often doesn't get factored in. And these cost savings could be reallocated like this bill does to victim services. We know that the system currently fails everyone, including victims and survivors, as well as folks who are criminalized, who are often the same people. So I just wanted to add that, and I'll pass it back over to Charles.
Well, thank you all for giving us this opportunity. You've heard from some of the people inside. Being currently incarcerated, I've done everything that DLC has to offer. There's nothing left it can do for me, yet I still have 2 decades to serve. At what point are we going to create a mechanism of second look? I've had the benefit. I'm one of the kind of rare situations where I got to go back and be resentenced. Had that day have never occurred, the healing that happened with me and the survivors never would have. Right? I had the opportunity to go back, be accountable, stand before the courtroom, my judge and the survivors, and admit what I did and be accountable. And it's not the punishment that makes me accountable. It's me inside that holds myself accountable for my wrongs. And I had the opportunity to hear the survivors in my case say, I forgive you. I didn't have that benefit at my first sentencing hearing when the initial impact occurred. But the opportunity to go back, have that second look, and the benefit of that allowed that healing to occur. They have the right to be present in person. They have the right to speak in person. They have the right to see it. It's a different process. Parole, they don't get that. Clemency, they don't get that. But through judicial review, we get there. We go back together. We heal together. And I ask you all to stand with us, support the JDA, and let's move it this session. Let's get it where it needs to go, and let's begin unwinding this damage. It's taken all of us to get here, and it's going to take all of us as a community to undo it. I know we talk a lot about the budget and costs and all that, but there's no price tag on what this is. It's never a question about how much it costs to incarcerate people, but it's always too much it costs when to recognize the wrongs that we've done. We know better. The data is out there. The research is there. we can certainly do better. And this is our year where we can make a difference. Let's make 2025 a year where we can feel good. Thank you.
Thank you, Charles. I really appreciate you sharing this vital information. I think this is vital information for our advisory committee to know. And so basically, Charles contacted OPD about 2 years ago to learn about mechanics. And so what we've done is come out with a way that we can implement it. And our will is to do what the legislature says for us to do, and what the voters say for us to do. And our job is to see where that fits within the public defense continuum. I think that we could get public defenders to do this work. I think it's important work, and we've come up with a plan that, if it's voted in, that we essentially created a triage plan to go along with this legislation. We don't want a situation reminiscent to Blake, where the courts are overcome because of these cases. And so we've thought of a way to reduce that impact, but still meet these needs. So I want to thank you for coming and presenting today. Thank you very much.